Hello, everyone. I'm attorney Chinwei Foster. We are continuing with our COVID-19 series, How COVID-19 Infects the Law. And I am absolutely honored to have the Chief Judge of Fulton County, Atlanta Judicial Circuit, the Honorable Judge Chris Brasher, with us today. Thank you so much, Judge Brasher, for joining us. How are you doing today?
Absolutely. I'm doing well. Thank you, Ms. Foster. It's a pleasure to be with you. And I hope that everyone who hears us is safe and well and that their families are too.
Thank you so much, Judge. And, of course, with everything going on with COVID-19, so many people, citizens, people who have cases in Fulton County, attorneys, we have a lot of questions. So I really appreciate you doing this and answering some of the questions that we have. So I'm just going to jump right into it. I know that the Chief Justice yesterday released an order extending the initial order that was entered on March 14th. Fulton County had an order that extended basically courts being closed or shut down or limited until April 13th. Can you tell me a little bit about the Chief Justice's order and how that will affect us, or affect Fulton County?
Sure. So the way that our justice system in Georgia works is we have a unified court system pursuant to the Constitution. And so therefore, I and several other judges around the state entered judicial emergency orders in mid-April. And then Chief Justice Melton entered his order on April 14th. And the effect of that order was to supersede all of the local orders. So our order, while it's still in effect nominally, is superseded by the effect of the statewide judicial emergency. And so yesterday, Chief Justice Melton entered the order extending the statewide judicial emergency for another 30 days until mid-May. We had a conference call yesterday with the Judicial Council, which is basically the leadership of all of the classes of courts around the state. And I serve on the Judicial Council because I'm the administrative judge for our circuit. And so therefore I serve on that. And I can tell you that Chief Justice Melton's intention is that all of the limitations on actions as far as time constraints, all of the stays and extensions of deadlines that occurred based on the original order remain in effect. If you take a look at that order extending the statewide judicial emergency, there are two extra things that he made special mention of yesterday, and it's important for your listeners to hear this as well. The first is that he has asked lawyers and judges to kind of begin working on non-essential things as best they can during this time so that we're not faced with quite so much of a deluge at the end of this process whenever we come out of it. So I'll say specifically civil matters, domestic matters, criminal matters that can be handled via teleconference. The Chief Justice's directive is that whenever we can, we should begin the process of folding those things into our regular activities. So many of us have been focusing on the essential things, which boils down to questions of liberty and personal bodily injury questions. And some of that, I won't say has passed, but certainly we've gotten over the initial hurdle of dealing with those and kind of regularized our processes about that over the last couple of weeks. So now's a good time for us to begin incorporating some of those non-essential things. And when I say non-essential, I don't mean not important, because they are important. All the matters that come before us are, and I don't ever intend to diminish the importance of them. But we certainly have been focusing on those things spelled out as essential before. But now his direction is that we commence dealing with some of those. So I hope what that means is that over the next week or so, you and your listeners will begin to see that other matters can begin to be dealt with, sort of regular things, mostly by teleconference. Of course, in Fulton County, we've been using Zoom. That's the platform we're on now, of course, but I know around the state, others are using WebEx and other products as well. Whatever they are, the direction is that we use those platforms and that we try to press forward with as many things as we can. The other directive that he gave us was for everybody to to be nice to one another, and not to make light of that, but this is a time where all of us are impacted by this differently. You know, some people who have important matters before the court also have personal tragedies and personal challenges that they have to deal with because of this. There are people who literally can't do what we're doing right now because they've got family members who are sick or children who are so young that they can't be cared for out elsewhere, and of course with the safety issues. So both in pressing forward with things when we can and being respectful of the challenges that people face, he's asked us to be nice to one another and to remember our mandate of professionalism. So those are really the things that he asked us to take away from that order yesterday in our call.
Okay, yeah, and I'm sure that's good for other attorneys to hear because, you know, we all have families or people who are working with kids and trying to homeschool their kids and go to work. So that's important, I think, for us to keep in mind because this is new for everyone. So we're going to have to kind of navigate it together. Now I have in Fulton County with 2 judges who are doing regular status conferences and hearings. So the idea after speaking with Justice Melton is that all judges in Fulton County are going to start hearing non-essential matters via Zoom.
Yeah, the idea is that we should ramp up our efforts to begin to address those non-essential matters. And of course, not only is it important because we don't want to be faced with a crush at the end of this process, but also folks have been waiting for a while and there are things that need to be dealt with. And so just from a carrying out our duty as judges perspective, as well as being proactive to avoid kind of the calamitous results of everything starting at once at the end of this, that was his message, was that all judges around the state should begin that, and specifically from my perspective, those of us in Fulton County.
Okay, so that means, for example, just to kind of go into non-essential in the criminal aspect. So plea and arraignment hearings, final hearings, things like that. Those are things that the court is going to start hearing.
Well, we've already begun to hear a fair number of pleas, jail pleas, with Zoom, and we're doing that. We have set up both for complex and non-complex Zoom court, where the judges will be in a courtroom, the attorneys will be located off-site, and then we have a mechanism where we're bringing the inmates in the jail to a central location on each floor, so they're not bringing them together for transmission concerns, but they're bringing them to a central location on the floor, and we're dealing with bond hearings and pleas in the jail. So the next step will be to see if we can do some of those things where defendants are not in jail, where we can do it, especially if the plea is to probation or something like that, then perhaps we can begin the process of doing some of those things. There are other legal hearings that can be done, whether it's a motion on something that isn't going to require the taking of evidence or minimal taking of evidence, perhaps. Those are things that can be done. Frankly, this is going to impact the civil and domestic cases more than it will the criminal. The reality is that defendants that are on bond are not going to be a priority while this is going forward for obvious reasons. We don't want to introduce more people into the jail for the reasons that I'm sure you've heard on the news. We have had some good results, some good news on that front, and that is that while we did have 18 cases of COVID-19 in the jail, all of them appear to have gotten better. We got 3 of them out to Grady who needed to be hospitalized, and the other 15 all weathered through it. And really only one of them was very symptomatic. The others were not, but they were all isolated in the medical area. And also the jail, for arrestees, they're keeping people separate for 2 weeks before they introduce them into the general population. So these are the steps that are being taken to try and keep people safe in the jail. And those who practice criminal law know that we're not letting lawyers go in to see their clients now. They can communicate via video link, but we're trying not to do that. Just an unfortunate reality, but an important story is that on March 9th, there was an inmate that was brought to the Fulton County Courthouse. And that inmate had had a communication and resolved a case with his private attorney and contracted COVID-19 from the attorney. Again, that's not blaming anybody or anything like that. I won't, of course, won't say names of who did it, but these were people who just were doing their job, and someone had been exposed and didn't know it. And, so that's how it got loose in the jail. And this was before we began any of this process of shutting things down. So you can just see how innocent the contacts can be that can lead to this. And of course, in a closed environment like the jail, we're just very protective of that. So we're trying to keep the numbers down in the jail. We've reduced the jail population by about 400 since the beginning of March, and done that through pleas, through bonds, through stipulated probation revocations. So I know I've gotten a little away from your question, but I just wanted to make sure that everybody knew that there are steps that we're taking, and it's not because we don't want to handle those cases, but we're trying to prioritize those that we can handle and get out of the jail as opposed to bring in. One last point I'll tell you is the Department of Corrections is not picking people up from the jail right now. So, and that's true all across Georgia. So we have about 200 inmates in the Fulton County Jail who otherwise would be ready to be taken out of the jail by the Department of Corrections, but because they're fighting their own concerns about COVID-19, they're not picking people up from the local jails all over the state. And so that's complicating things. So therefore, we're not taking pleas to confinement time because that's not going to make a difference on the jail population. We're trying to take pleas and handle cases where it will result in an inmate being released.
Okay, and now just to get some clarification. So like, for example, I know that the magistrate judges in first appearance cannot set bond on certain cases. So
Right.
if someone would otherwise meet all the Ayala factors to qualify for bond, if they don't get bond at first appearance, so you would suggest that attorneys file maybe bond motions in front of the presiding judge, maybe to try to get heard if they would otherwise meet the Ayala factors and qualify for bond, correct?
So we have a presiding bond calendar that all the presiding judges are doing, and that's being done via Zoom as well. I will say that those are for unindicted cases. So usually 7 deadly sin charges where the magistrates are not empowered to set bond. Oftentimes those will end up on a presiding judge calendar and be handled that way. Of course, you can also bring it to me or one of the other judges if you're not able to get through that process. Of course, because there are no juries, there are no grand jurors, we're not indicting cases now, and so that's a complicating factor. Fortunately, the numbers are fairly low on the serious cases that have entered the jail and I say serious based on charges that have entered the jail over the last 30 days. But of course, we want to still address those as we can.
Correct. So hopefully people are staying at home and not committing any crimes then to keep those numbers down.
If that's true, I hope it continues after this.
Yes, definitely, definitely. Now, just kind of talking about indictments, just to kind of segue, the order by Chief Justice Melton mentions that, things are told, such as speedy trial, the time that the state has to indict, but there's really no clarification on discovery. Does the state, so now that we're going to begin doing plea and arraignment and non-essential hearings more regularly, is the state still bound by the discovery rules to make sure that they get defense attorneys discovery on time so that we can investigate the case and do what we can while we're going through this?
So I'll answer that with a little bit of further information, and that is that specifically the Chief Justice has said that all deadlines are told by this. And he includes in that civil discovery. And so it may well affect criminal discovery as well. However, this is back to we should play nice with one another. If we're going to get cases on arraignment calendars, if we're going to have kind of regular operations of non-essential matters, non-critical matters, then we're going to have cooperation. We're going to have, folks are going to have to file opt-ins, and we're going to have to address motions that are filed and the state's going to have to provide discovery, because otherwise those cases can't move forward. So there is a little bit of a tension perhaps between those two things, but I think, again, as we begin to address how to move forward, especially using technology like the one we're using now, we need to be ready to comply with those requirements, irrespective of being relieved from those obligations by the standing order.
Yeah, that's good to know because, I mean, as you know, I do criminal and family, and I have some family cases where, of course, the goal is to try to resolve these cases while we're in front of this without judicial intervention. And not being, because it is told, I guess with this, we now know, even though it's told if we're trying to resolve the case as attorneys, we should still be exchanging discovery if we can, correct?
Yes, and again, the last phrase you used, "if you can," is important. I mean, I have civil cases pending right now, and of course, there aren't going to be any in-person depositions. There aren't going to be some of the things that require, if there's voluminous discovery, one lawyer goes to another's office to look through, if they're physical documents that aren't amenable to being scanned, et cetera. Of course, if there's electronic discovery or things that can be imaged and sent, then those should be done that way. But there are some limitations. I think, as they say, necessity is the mother of invention. And so in that vein, there are lots of folks that have discovered virtual depositions and discovered how useful they are, just like we're using this platform here. So I think, again, as we, as lawyers and judges, begin to stand back up our responsibility to keep these cases moving, we'll need to continue to leverage those tools.
Okay. And one thing I know family law attorneys that we haven't really received much guidance on is emergency custody or contempt hearings. Of course, we have clients who have concerns about the child going to the other parent's home and possible the other parent not following the guidelines, not abiding by the shelter in place order. Should we as family law attorneys be filing emergency motions for contempt or just custody hearings if those issues come up with our clients?
Well, you know as well as I do that there's the old joke about what's an emergency. There's what the client thinks is an emergency, what the lawyer thinks is an emergency, and what the judge thinks is an emergency. And I don't say that to be flippant. I say it to say that understand that if there's a real emergency, and my definition was always, is somebody presently in danger? Or are they going to be in danger in short order unless somebody intervenes? And danger, of course, in this time, the definition can be expanded, and I understand that. If someone in good faith believes that, and you as counsel are convinced that that's a real circumstance, then I think those motions should be filed. Okay. I'll say two other things. One is Governor Kemp issued some clarification on the Friday that the shelter-in-place order came into effect, and it clarified what the order does not affect. And it came out on April the 3rd, and it specifically says that it doesn't affect the actions by the judicial branch. That was the executive branch staying in their lane from a separation of powers standpoint. But effectively, it means that the custody orders still mean what they say, and they should still be abided by. We've all unfortunately seen circumstances where folks may use the advantage of a circumstance to their advantage when it comes to a custody fight. When it's something that happens from outside the relationship, but whether it's an act of God or something like that, that people will perhaps take advantage of. And of course, that's what the order was designed to avoid, that circumstance. But of course, there's still a judicial process. And if someone believes that another parent is acting dangerously toward the child or is endangering the child through inaction, then those are things that always should be the focus of an emergency motion. And those things can still be heard. This is back to when the lawyers take those cases to court, whether it's as the petitioner or the respondent. This is where the officer of the court role becomes super important, because these things are important to someone. These issues are important to someone, and we as judges are going to try our best to hear them. but we're going to need some cooperation in order to do so. And that may mean being willing to do it via Zoom or some other platform.
Okay, yeah, that's helpful, Judge. And also another thing that I know, I've interviewed some doctors and individuals who have said that during this time, while there is a shelter in place and everyone is quarantined, that there has been a rise in domestic violence, or children being in danger. Can you? And there's a lot of confusion as to TPOs and the TPO court. If there's an extension in the 30 days that it has to be heard by, people don't really know what's going on with ex parte. Can we still go before the court? Can you give a little bit of insight on that?
Sure. So in keeping with the addressing essential matters, the 30-day ex partes, the ex partes are still occurring. We get an average of 8 to 10 a day at the courthouse, even during this time period. And that's been pretty consistent over the last 2 weeks of this, or 2.5 weeks of this process. In addition to that, there are some 30 days that are going forward. However, I signed an order a couple of weeks ago, or about a week and a half ago, that extends all of the 30-day orders, all of the ex parte orders until further order of the court. And that's because of Justice Melton's order for statewide judicial emergency. So those ex partes that are in place, and look, I understand the hardship that has worked, because there are, as with every process that we have, there are some folks that might abuse it, and they might get an ex parte order as a tool to hold over someone else's head. In the main, the idea is that we want to promote the idea that if someone has a situation where they are being abused, that they should be able to go to court, get an order that stops that from happening as best they can, and that we shouldn't punish someone who's in that circumstance because there's no court to go to follow it up. And so, understanding the difficulty that it works in other circumstances, we've tried to address that as best we can this way. So my message is TPOs are still being issued. There is an order that extends them because all the deadlines are told, and we'll get back to hearing more of them once this passes by.
Now, Judge, as a defense attorney, what I think about is, I know that each case is looked at on a case-by-case basis. So with the TPO, if I have a respondent who has been kicked out of their home, and it's going to go past 30 days, is it a good idea for me to, given that that's a particular situation where there might not be basis, there might not be evidence, is it a good idea for me to still file something to the court to try to get it heard within the 30 days?
I think there's nothing wrong with doing that. I think the difficulty is that what I'll say is, this is one of those times where it may pay to be creative. And so not all TPOs end up with divorce cases, or not all TPOs end up with legitimation cases, but many do. And there are other processes that might be available in those forms of civil action that might be more accessible than going through the TPO process. That's not a one-size-fits-all answer, but there are circumstances where that might make sense.
Okay. Now, Judge, another thing that I know that you are the Chief Judge of Fulton County. Given that you had a meeting with the Chief Justice yesterday, do you know whether there's some discussion about uniformity within Metro Atlanta with all the courts? Have that been discussed?
So again, as far as uniformity is concerned, the Chief Justice's order supersedes all the other emergency orders that were entered by the various jurisdictions. Some had not gotten to the point of entering them yet, but this order, the Chief Justice's order, is the, for lack of a better term, the law of the land in Georgia right now. As is true of every circumstance, however, the way it works in one county may be different from another. There have been several counties where court has been closed, not the least of which down in Dougherty County because of the outbreaks there. But it also happened in Henry County where there were outbreaks in the courthouse, and it happened in DeKalb County because of what happened in the deed room there and the unfortunate loss of life that occurred with Professor Stevens' wife, who taught me when I was at Georgia State, by the way. So I was so sorry to hear about that. But I will say that absent those closures, what I hear from judges across the state is that they're doing their best to be able to operate as they can with the technology that we have. Most counties have come to the place where Fulton County has, and that is we're not bringing inmates to the jail anymore, or excuse me, from the jail to the courthouse anymore. Most counties around the state have gotten to the point where they're not bringing inmates to courtrooms that might be located in the jail, like we have in Fulton County. Mm-hmm. And again, the reason is because in order to do that, they've got to move inmates throughout the institution. They've got to bundle them together in ways that's not appropriate for social distancing. And so all of those realities have slowed down a lot of processes when it comes to criminal matters. Now, when it comes to civil matters, I practiced in 130 counties around the state when I was a lawyer, and sadly, there are a lot of inconsistencies even in places where you would hope there wouldn't be. But you know, I know that my fellow judges, from what I've heard, by and large, are doing their best to try and keep things moving. And I hope that this advice that we've gotten from the Chief Justice will help us with that.
Hopefully. I know that I have had 30-day statuses with Judge Edwards. I've had hearings with Judge Glanville. So I know the judges in Fulton County are working, because I was in court 3 days last week. So I know that it works. So hopefully that continues. And in that same vein, Judge Brasher, I know one thing that a lot of attorneys complain about is having to travel just for a calendar call just to announce ready. That is costly to the clients in civil cases, and it's time consuming in criminal cases. So now that we see that this virtual teleconferencing works, do you think that in the future that we can go to report in, instead of having to drive an hour through Atlanta traffic, to just say we're ready for trial or we're not ready? Do you think that this will carry on after this is over?
Gosh, I hope so. You know, as again, as somebody who practiced all over the state, in my practice, you know, everybody loves a field trip, but it's not great to have to do that for something that's basically unnecessary. You know, I'll tell you my experience, and that was when I thought about becoming a judge. One of the things that I said was, what are the things that I had to do as a lawyer that I didn't want to have to visit on other people? And one of them was civil calendar calls. So I've never had a civil calendar call. I don't do calendar calls for family cases. Everybody gets specially set. You know, I did that. I know that's helpful to the lawyers, but it was what I wanted as a lawyer. And so that's why I did it. And I hope that this unfortunate circumstance that we're all going through is a learning opportunity for all of us, and not just judges, but lawyers too, that, you know, we can encourage this kind of behavior where we do what we need to do, but we don't do it because of the 100-year rule. We don't do it because that's the way we've always done it. You know, this has been an opportunity to examine some of the things we do and really come to grips with whether we need to or not. You know, I enjoy doing status conferences via telephone. I find that oftentimes they're more productive. Than, you know, people don't come to court in the posture of coming to court. There's always a little bit of a show to that, and I understand for client purposes, there's always a little bit of theater that goes along with that, and perhaps that can be avoided if we do it by phone. So I'm all for it. I'll encourage it, and I hope that it comes to pass.
Hopefully, Judge, and that's one of the reasons that I can say that you were greatly missed in the family division in Fulton County. I'm sure every attorney will vouch for that. I guess this is kind of a good...
I enjoyed my time on family, so thank you very much for saying that.
Of course, Judge. I guess this is a good place to close. And before we go, Judge, do you have anything to say to attorneys, our clients, citizens of Georgia, Fulton County, who are watching this? Is there anything, any parting or closing words you can give to us?
Well, of course, I want to begin by saying that I hope you and everybody else who's hearing this remain safe and well during this process. You know, I think we've learned what we need to do to try and minimize the spread of this. The question is whether we continue to have the will to do it, and I hope we do, because I know all of us yearn for some more normal times. I will say that, you know, one of the things that we didn't really talk about today was jury duty, and you know, we've stopped all the juries in the whole state. And so when people ask about when are we going to start back up processes, the question I tell folks is, if here's my test that I would ask you to employ on how this happens, and that is, at what point from now would you be comfortable sending your loved one to sit in a room with 300 people that they don't know? Because that's really the test of when we're going to get back to normal on dealing with juries. And it may be months, I don't know. Certainly that doesn't mean it's going to be months before we start more regular business in the courts, but you know, these are things that we have to consider as we start back up again. And so I ask folks to be patient with us. I think they should expect that we will do our jobs. They should expect that we'll do things as the Constitution and laws require us to. But again, some of that advice from the Chief Justice about everybody being nice to one another, I promise I'll listen to whatever concerns people express to me, and I'll tell them the best answer I can. And I ask folks to approach things that same way. Just try to be productive with whatever you do, and I think you'll find that the response is good. So thank you for the opportunity to talk to you and to all of your listeners as well.
Of course. Thank you so much, Judge Brasher. I really appreciate it. And again, everyone, that's Chief Judge of Fulton County Superior Court, Atlanta Judicial Circuit, the Honorable Judge Chris Brasher. Thank you so much, Judge, for being with us.
My pleasure.
All right. Thank you. Bye-bye. Thank you again to Judge Brasher, Chief Judge of Fulton County Superior Court, Atlanta Judicial Circuit, for taking the time out to answer the questions that so many of us have. Thank you all for watching our COVID-19 How It Infects the Law series. I am attorney Chinwe Foster with the Foster Law Firm, where we specialize in aggressive and effective legal representation. Thank you for watching.